If you are counting down to 5-year ILR finish line, stop scrolling, because one phrase could change your entire plan. We will apply the rules at the point you apply. Subscribe now, because the next few months will be full of rule changes and headlines, but I'll translate what Parliament and the Home Office are actually saying into what it means for your real life, your family, and your settlement clock. Now, let me start with a story, because this topic is not a theory. It's people, it's a family who delayed having a child because they said once we hit 5 years, we breathe. It's a care worker who stayed in a tough job because the promise in their mind was 5 years, then security. And it's thousands of people who built a life plan around one number. I am Sajjad Kayani, a London-based UK immigration, family and civil litigation solicitor. Laws are changing fast and experience matters now more than ever. I have been practicing for the last more than 19 and almost 20 years as a solicitor. Here is the question everyone is asking, and I am going to answer it properly today. But not all at once. Can the government really change the settlement rules and apply them to people who are already here? Because that's what a retrospective feels like. The goalposts move after you have already started running. Now, first twist. In law, retrospective has layers. There is true retrospectivity, punishing you today for something that was lawful yesterday. And then there is something more common in immigration, changing the rules for the future. But those future rules catch people who are already in the UK and haven't yet applied or haven't yet got a decision. The second category is the battleground. Now, watch this, because this is not coming from rumors. This is in Parliament evidence. On 4th of Feb 2026, the Home Secretary told the Home Affairs Committee two crucial things. First, the consultation had something like 130,000 responses. That tells you the scale of concern. Second, he emphasized that ILR is assessed under the rules in force at the time that you apply, saying this approach has been tested and upheld in case law since 2009. So the government's argument is simple. This is not a retrospective punishment. It's how the system works. Rule changes and your application is judged under the rules in force when you make it. Now, hold that thought, because here comes an element number one. Is that statement the whole legal picture or just the Home Office best argument? I'll close that element in a moment. But first, you need to understand why the government feels confident saying this. In immigration law, there is powerful principles from the House of Lords in 2009. And that principle and case law is Odelola. In simple English, the message of Odelola is, unless there are clear transitional provisions saying otherwise, the decision maker can apply the immigration rules as they stand at the time the application is determined, not necessarily the rules you expect when you entered, and sometimes not even the rules that were there when you first applied. So if you are thinking, I came under the 5-year system, so they must keep me on that path, Odelola is the legal answer the Home Office will lean on. But there comes another element number 2. If Odelola is so strong, why are human rights and immigration lawyers like me and campaigners talking about fairness, moving the goalposts and transitional protection? Because Odelola is not the only story. Now, let me introduce the case line that every serious immigration lawyer should have in mind when government try to tighten rules mid-journey. HSMP Forum. Back in the highly skilled migrant program era, people entered the UK under one published set of expectations. Then the rules tightened for extensions. The HSMP Forum brought a judicial review arguing that people who had already joined under earlier terms had legitimate expectation that the strict extension test would not be applied to them. And the High Court agreed on that point in 2008. So much so that the Home Office produced a policy document to give effect to the judgment, confirming that for migrants who already held HSMP leave, the extension requirements would be the earlier pre-change requirements. Now let's translate that again into easy English. HSMP stands for a fairness warning. If the state invites you onto a route and its material creates a clear expectations, it might not be lawful to quietly tighten the test against people who are already on that route without proper transitional protection. So here is the balanced legal position, and this matters. Yes, the Home Office often can change the immigration rules, and it will say your application is assessed under the rules in force at the relevant time. But HSMP shows that where the government has created a clear and relied upon promise about the pathway, public law can require fairness, sometimes through transitional arguments, sometimes through exemptions, sometimes through protecting in-fight applicants. Now, I am closing element number 1. The Home Secretary's rules at the time you apply point is a strong, and it's a strong Home Office argument, but it is not a blank check. The harder they push the change onto the people who planned their lives around an existing rule, the more pressure builds for transitional protection politically and legally. So what does transitional protection actually mean here? The Home Office consultation itself defines transitional arrangements as a temporary measures designed to ease the impact of new rules for those already in the UK and already on a pathway to settlement. And in the Home Office Affairs Committee, the evidence the Home Secretary openly accepted that big changes are potentially happening and that it was inconceivable. That's what Shabana Mahmood has said. That nobody currently here would be affected, while also saying the consultation is genuinely open on transitional arrangements. This is the key point. The fight is not only will the rules change, the real fight is who gets protected while they change. So I'm going to repeat it again. The real fight is who gets protected while the rules going to change. So now let me move on to element number 3. Who might be exempt or at least protected based on what has already been published? Here are the clearest categories you should know based on official consultation text and parliamentary evidence. First, some groups are already set to keep a 5-year route within new framework. Through a built-in reduction, the consultation says that people on specific routes, such as those admitted as the partner's parent or a child of a British citizen, meeting core family requirements, and Hong Kong B&O route holders will attract a reduction so they can still settle after 5 years. Of course, subject to mandatory requirements. Second, the consultation proposes accelerated settlement for some high-value routes like global talent and innovator founder, where a reduction can bring settlement down to around 3 years, again subject to mandatory requirements. Third, children. This is important. In the 4th of Feb 2026 evidence session, the Home Secretary said those in care or who arrived unaccompanied were taken out of scope of the consultation. And that earlier white paper commitments about children who grew up in UK without status would be unchanged by these proposals. Fourth, borderline cases. The House of Commons Library briefing notes that transitional arrangements could exempt some people already in the UK and highlights that an accompanying government press release to this effect suggests this might be considered for borderline cases. If you are close to eligibility, that borderline idea is exactly where real-world protection could land. Now, let's turn this into practical strategy because hope is not a plan. If your ILR is within reach, you must behave like a careful person, not a relaxed person. So step 1 is audit your eligibility early. Don't wait for the last month because timing is now a legal risk, not just an admin details. Step 2, get your documents and your life evidence organized now. Residence, absences, work history, tax, NI records, any issues that could become mandatory refusals. Under an earned model, you don't want surprises. Step 3, if fee are the reason you delay, treat this like a monthly savings plan because the risk is simple. You delay, the rules shift, and you lose years. And here is a line I want you to remember because it's true in immigration law and in life. You cannot control the weather, but you can control whether you carry an umbrella. Now, if you want me to further cover these transitional protection in detail and what it could look like and what arguments actually work, comment one word, transitional. And of course, subscribe because when these changes move from consultation into immigration rules, the people who win are the people who prepared early. Before panic, before rumors, before deadlines. You are not powerless, but you do need to move early. See you soon.